We're going to turn to some other news now coming from the nation's capital. The Supreme Court of Canada has dismissed the case of a 14-year-old Manitoba girl who was given a blood transfusion against her wishes, but it also agreed with her on an important point. Margot McDermott joins us live from Ottawa with the details. And Margot, this girl argued her rights were violated. The court disagreed. Give us the details.
Well, Andrew, what she was arguing in court, in fact, in Manitoba and then here at the Supreme Court, was that she argued, and the judge said she had to have this transfusion. But the Supreme Court disagreed with her arguments. She said, the court said that the law actually in Manitoba is fine, that it stands up, and that it actually does balance the rights of the young child under the age of 16 and the needs of requiring a judge to also consider what that young child up to 16 wants. So it did strike a good balance. So it disagreed with the young woman, AC, on her argument that the law should be struck down. The Supreme Court also disagreed with her on the point that the law violated her constitutional rights. She said that by giving her this transfusion, because she was a Jehovah Witness, that her rights were violated, including her right to religion, freedom of religion. The Supreme Court disagreed with that as well. It said that the law still does strike a balance between the choice of the child and the need for the state to protect the child, and that this law is not arbitrary. It doesn't just say, because you're under 16, this has to happen. It does sort of take into account the needs of the child. So it also disagreed with this young woman on the point that it violated her constitutional rights.
However, Margot, this wasn't a complete loss. The court did agree with one of her key arguments. Tell us about that.
Yeah, it was an interesting sort of win-lose situation, or lose-win situation, Andrew, that the Supreme Court actually pointed out that AC made a very convincing case that young people do have a right to determine their treatment, their medical treatment in particular, because when she went into the hospital, she signed a form that said she did not want a blood transfusion. So the Supreme Court said that, yes, young people, especially people who are mature for their age, should be assessed. They should analyze the situation, and if they can make a good argument, they do have a right to determine their own treatment. Ultimately, though, of course, they don't have a right to put their own lives in jeopardy. So there's kind of a sliding scale. But it sort of clearly said that from now on, right across the country, when young people are receiving treatment in hospitals, and ultimately, if it does come to the courts, they do have a say in their treatment. Here's a little bit more from AC's lawyer, David Day.
The court has made it clear that when a young person demonstrating sufficient maturity expresses particular treatment choices, the court has to give effect to those treatment choices, provided they are sufficiently mature in the context of the involved treatment.
And Andrew, there's another win for this young woman who is now, in fact, 18. This case happened a couple of years ago. The Supreme Court awarded her costs. In other words, the Manitoba government has to pay her legal costs for this lengthy hearing at the Supreme Court. And those costs could reach at least $450,000. So that is ultimately another win for her as well.
Yeah, absolutely. All right, Margot, thanks very much. CBC's Margot McDermott outside the Supreme Court.